Thank you, everyone. I'm delighted to be here. I'm going to let Christy zoom in on my lovely appearance, so make sure that our friends online can participate fully. One of the things I want to do to start with is correct something in the materials, I'm afraid. The very first cover page, I want to point out that our firm, Whitfield & Eddy, is no longer at 317 6th Avenue. I had a correction page I was hoping was going to be inserted. Unfortunately, it didn't make it. And Whitfield & Eddy is currently at 699 Walnut, Suite 2000. We're in the Hub Tower now as of 3 months ago. So anybody who didn't know that, that's where we are. Second thing I wanted to kind of ask is, Matt Doré in the room by chance? Professor Matt Doré from Drake? Pat Bauer, are you here? I didn't think they would be. They've got things to do in their respective law schools. But I'm going to send this first case to them, because if this isn't a law school exam question for secure transactions, I've never seen one. I had the privilege and honor to actually replace, if you will, Matt Doré for a year while he was on sabbatical teaching secure transactions at Drake. And I can appreciate how difficult it is to prepare law school exam questions and then to actually grade the darn things. So this is one of them that I think that you might find interesting if you take the time to read this. This is a fairly complex and long case, this very first one, but let's talk about it. What this case is about is the ability to secure an interest in a commercial tort claim. But what the case also presents is all sorts of issues regarding Article 9, priority of claims, whether filing or perfection. When is something perfected? When do proceeds actually get you something more than actually the original security interest? After acquired property attachment. It is just one of those kind of cases where everything seems to be discussed. But let me read a little bit. I put in here, this is a little longer presentation of facts than normally, because I think they're important for you to get the gist of what we're trying to do here. Texas Rice Mill and Texas Rice Inc., or that's Texana, we're going to call those, sued Bear, that's the big Bear company, in state court, and got removed to federal court. They brought 5 claims against Bear, including negligence per se, and strict liability, private nuisance, and what this was really about is it was claiming that there was when there were costs to decontaminate the property from the rice that was provided by Bear. It was treated rice, and all these things damaged their property, caused them loss of income. So what they provided here is then asserted is they had property damage, plant and equipment from Bear rice had to be replaced, lost profits, unrecovered costs due to unmarketability of its contaminated rice, loss or diminution of value of its plant, equipment, and improvements, lost future profits, including financing costs and others. I point that out because what they did is that they had some property get damaged. They also had some claims for just money damages. Keep in mind this lost property, this damaged property issue. Well, after about 5 years of litigation, the case settled. Now, all the parties to the Bear suit basically authorized the court to distribute some of the proceeds, and then there was about $900,000 left over, and 2 creditors started fighting over it, and that's what this case is about. Is priority rights to that leftover proceeds of about $900,000. Amegi, who is a bank, loaned Texana $2 million in 2006, secured by collateral including inventory accounts, equipment, furniture, fixtures, just the normal stuff. Well, Texana defaulted on the loan in 2006, and in 2007, Texana and Amegi entered into a forbearance agreement. Not an unusual situation. You've all done them. And we're going to let these guys have a little bit more time, 2006. They said they're going to do that in exchange for a security interest in the Bear suit. Remember I said the Bear suit didn't settle till 2012, but it was in existence at this time. So Maggie perfected its interest in the claims agreement by filing a UC financing statement specifically describing this Bear multi-state lawsuit. Now, Stearns is the other creditor. Stearns Bank is the other creditor, and they loaned Texana, the debtor, $2.6 million in September of 2002. That's way before Maggie loaned them money. They were in 2006. So they had granted a security agreement describing fixtures, chattel paper, equipment, general intangibles, I point that out, excluding inventory and accounts receivables, and the description also included proceeds, which you don't have to put in a security agreement. You're automatically secured in proceeds for the most part. Stearns filed a financing statement describing the collateral in 2002. So Stearns had this description of all this equipment and also all of this general intangibles well before Maggie did. But Maggie did have one thing in their security agreement that wasn't in the Stearns security agreement, and that's this Bear lawsuit. Now, after Texana defaulted on the Stearns suit, Stearns got a judgment in 2010, $3 million plus, and foreclosed on a deed of trust and the security agreement. And 3 days later, bought all of the collateral at foreclosure sale for $268,000. So they've already got their collateral back in the form of equipment. Next, what's going on here? Stearns has moved that they're entitled to the proceeds of this, what they call a general intangible, these proceeds from the Bear lawsuit. The court recites a plethora of UCC law, so if you want to read it sometime, maybe you'll find it interesting. But the court also notes that you can't just describe, to get a security interest in a lawsuit, you have to specifically describe it. You can't just describe it generally. You can't say just commercial tort claim. You can't just say obligations that come from lawsuits down the line. You have to have something specific named in order to do that. That's a restriction of Article 9. Stearns argued that it filed first and perfected its security interest in the settlement payment at two different forms. One, they described it first, they had after acquired general intangible. Well, the court very correctly notes that payment intangibles are a subset of general intangibles, and there's under which the account debtor's principal obligation is a money obligation. Stearns contends that it has a security interest in the settlement payment because it's a settled tort action, and that's a payment intangible. And the comment to the UCC actually, uses that as an example. It is a payment intangible. So we've got an after acquired payment intangible at stake here. Their security agreement attaches. Aren't they first? They filed first. That's not what happens here. Court ultimately decided that Maggie had the superior security interest. And what they said was, I'm going to quote here, I think it's important that I put it in, that the settlement payment is proceeds of the Bear suit. Maggie's interest in the settlement payment was perfected when its interest in the Bear suit itself was perfected. And at that time, Stearns didn't have a security interest at all in that collateral. So we've got a perfected security interest in the original collateral, and when it turned into proceeds, the proceeds statute simply lets you go back to the time when you originally filed. And Stearns couldn't say that they ever had that collateral as original collateral. And the fact that it was after acquired payment intangibles means that Maggie always did and first had security interest perfected in the original collateral. And that's why they won. As of the point in time when the lawsuit existed, before it was settled, Maggie was the secured creditor, and technically, because there was no description of a tort claim in Stearns' security agreement, they were an unsecured creditor as to that collateral. And that's the point where it goes forward. And anything after that, it's just proceeds and priority after that. So They ultimately found that Amegi remained the sole holder of the perfected security interest in the settlement payment, and they won. Anything occur to you, or anything that's have questions regarding that particular sequence? Did you get what I just presented? All right, let's go on. The second case is actually a subsequent reiteration of the Bear case, and I only put it in there to correct what the court made a misstatement about in the prior appeal about conflicting perfected security interests in proceeds. So I just put that in there as something that I thought was interesting for purposes of correction. We had a proceeds issue here in Iowa for years. Back in the 1980s, excuse me, we had some farm credit cases that went up on appeal, and the court made what I thought at the time was a misstatement of the law regarding proceeds and the priority in proceeds, and and had to do with course of dealing. Well, the court never did have an opportunity, or nobody ever corrected it. And until I had a chance to have an appellate case about 4 years ago or so, and the issue actually came up. And I'll be darned if the Iowa Supreme Court didn't say, you know, we were wrong back in 1989. They actually said that. They said we were wrong back in 1989 when we said that. We shouldn't have said that. Here they went right up, the appellate issue came right up afterwards, and they corrected it right away. So the next case is In Re Knight, and this is a case involving liquidation of crops and equipment. A secured party's lender's collateral. That's the debtor went and liquidated the collateral. And after he got done liquidating the collateral, he goes and says, well, I can't make my payments. And oh, by the way, lender, you were involved in this liquidation, and you didn't send out a sale notice. You didn't send out the UCC sale notice that I'm supposed to get. I'm entitled to not have to pay for the deficiency because that's commercially unreasonable. Well, the court didn't have anything, didn't buy that. And what really happened here was that the debtor was actually the one that was doing the liquidation. The debtor went to the lender and said, hey, I'm not going to farm anymore. And yet the lender was involved and had knowledge of what was going on. The lender said, yeah, that's great. Go ahead and liquidate things. The lender actually knew who the auctioneer was going to be and had conversations with the auctioneer. But the question really was, who was selling this collateral? And so for the debtors counsel and for the creditors counsel in the room, make sure that when you're counseling your clients that issue is made clear so that they don't have this kind of an appeal that actually takes place. Here, they went through an evidentiary chain of what actually occurred. There was a lot of evidentiary presentation on what actually occurred so they could identify who sold the collateral. Was it the lender or was it the debtor? The debtor voluntarily contacted the lender, informed him about his discontinuing farming operation. The lender didn't withdraw its financial support of the debtor operation or force him to cease farming. There was an evidentiary presentation on that. I mean, you could have solved all of this without any real difficulty by simply having a short agreement about who was going to be doing this. Second, the debtor proceeded to market and sell the crop without intervention or oversight by the lender. Third, the lender never resorted to engaging an attorney. What if they had? And they likely would have in a lot of cases. Well, that may be a factor in determining whether or not the lender was actually involved in the sale. Fourth, the lender didn't repossess or dispose of the equipment, didn't exercise actual or constructive possession of it. Constructive possession. What if they made certain requirements and restrictions on the sale, pointing out how it could happen? The debtor voluntarily assembled the equipment. The debtor himself chose the auctioneer, but in this case they also showed that the bank had some suggestion as who that should be or might be. So when does a pig become a hog there? Seventh, the debtor and the auctioneer spoke by telephone at least 17 times. That was probably, I saw in the evidentiary presentation, probably the kicker. It was the debtor who was calling the shots with the auctioneer. Ultimately, in this case, the court, and I think very correctly, found that there was no sale by the lender. The lender didn't control this sale. And the court, I think, correctly found that when the debtor's doing the liquidation, the UCC requirement for this UCC notice of sale is not required. And there's no violation of commercial reasonableness, even if the sale doesn't turn out well. So that's one way that you can, as creditors, as a creditor's counsel, guide your client to get to an amicable and maybe risk-free method of liquidating collateral. As long as you trust your debtor to do it well, you think that the collateral is going to be sold in a proper manner, a commercially reasonable manner, and he's going to turn over the proceeds. So that's the last. This next case is an Article 9 case, really, to begin with, and it's one I think is worth talking about in a couple different frames. BMW Financial Services had a loan with a woman named Nelson to finance the purchase of a 2011 Chrysler 200. And according to Nelson, BMW accepted those payments and failed to notify her that strict compliance with the payment schedule would be required under the loan. And what she was doing was she was making late payments, and they were letting her make late payments. But what the problem is that there's a case out there in Minnesota, and it's applicable in a lot of different jurisdictions. It says something to this effect. This is Cobb versus Midwest Recovery Bureau Company, which held that, quote, the repeated acceptance of late payments by a creditor who has the contractual right to repossess the property imposes a duty on the creditor to notify the debtor that strict compliance with the contract terms will be required before the creditor can lawfully repossess the collateral. If you've got a course of dealing between the lender and the debtor, you've got to give the debtor notice that strict compliance is going to be required from then on. You can't just declare default because they've been making late payments the whole time. You've got to undo your course of dealing. And then once you've given that notice, and then they continue to violate the strict compliance of the terms, that's when you have a default. So that's the real question. That's what really happened here is, when does a creditor, secured creditor, have a right to go and repossess? That's a simple law school question too. Under Article 9, upon default, you have a right to possession as a secured party. Upon default. And here, the initial discussion was, you didn't have a default. So what happened here? The creditor goes and tries and repossesses the vehicle. And they repossessed without undoing this course of dealing. It's commercially unreasonable repossession. Automatically, all of a sudden there are damages being asserted. And this is a consumer context, so consumer damages are actually going to be at issue. But it gets a little more complicated than that. Because the creditor, does the creditor bank go out and actually send one of their employees out to pick up the vehicle, which, by the way, was done over the objection of the owner debtor? Well, no, they sent out All Wheels. All Wheels went out and did the repossession. They're a contractor. All Wheels then is tarred and feathered with the commercial unreasonableness and lack of default that the lender is. Both parties are going to get tagged potentially for doing something that the law prohibits. That's what the next part of the case is about. It says that if you're going to go out as a contractor, I would suggest if you're representing contractors who do this kind of work, they need to have an indemnity agreement with the bank or with the lender. Conversely, the bank probably wants to have a similar contract that says, hey, if you do something that breaches the peace, we're asking you not to breach the peace. If you do something to breach the peace, it's on you, and you got to indemnify us. Now, those indemnities are only as good as the party's ability to pay, but it's something you should consider when you're using contractors to do collection work. Well, All Wheels was being, that's the third part of this case, is that the consumer debtor was saying, hey, I have consumer damages. I have damages under Article 9, 625, which say, damages for noncompliance losses subject to subsection C, D, and F. A person is liable for damages in the amount of any loss caused by failure to comply with this article. Loss caused by failure to comply may include loss resulting from the debtor's inability to obtain or increase costs of alternative financing. And then under C2 it says, if the collateral is consumer goods, a person that was a debtor or a secondary obligor at the time that the secured party failed to comply with this part may recover for that failure in any event an amount not less than the credit service charge, the interest, the amount of the interest that's been charged, plus 10% of the principal amount of the obligation or the time price differential. They can get this, they can get the financing charges as damages against the lender. Well, in this case, the lender actually was, those would have applied to the lender. Then the next question is, well, do they apply to All Wheels, the contractor? And the court found that the C2 doesn't say anything about contractors. It talks about the secured party. So it ultimately concluded that while All Wheels was potentially liable for actual damages, it's not liable for the statutory damages that we just read. Contractor is not covered by the statute. It's the secured party. Any questions? This next case is actually an Iowa case. Des Moines Flying Service. And it's an Article 2 case, but it's got a little wrinkle to it that I actually didn't know. I like to think I have a lot of experience in some of these lien cases, but there was a statute of which I was not aware. I hope you learn it too today. Maybe you already know about it. Case is about, there was a replaced airplane windshield. The airplane owner went in and said, something's going wrong here. I think we better have this replaced. Des Moines Flying Service replaces the aircraft windshield, and then it cracked in flight because of a manufacturer's defect. It didn't crack because of the installation, and Des Moines Flying Service didn't manufacture the windshield. Des Moines Flying Service is the defendant. Plaintiff sought recovery from the installer, Des Moines Flying Service, not the manufacturer. And the court tries to determine whether, and they sued him for breach of implied warranty of merchantability, and said that they didn't have to pay for the installation costs. They shouldn't have to because it cracked. Well, the court stated that the Iowa UCC applies to mixed contracts of goods and services, citing another Iowa case. It says, and they determine which actually applies, though, whether this Article 2 applies as to whether it applies to goods. Article 2 doesn't apply to services, if you recall. So you have to determine what the predominant factor, the thrust, the purpose, reasonably stated, and it is whether it's the rendition of services, which is goods incidentally involved, or is the transaction a sale with labor incidentally involved. This is an evidentiary question that came up, and the evidence that they showed was that the total bill was like $19,000. Only $6,000 of that or so was for labor. Most of it was for the price of the windshield. So they called it a sale of goods. They said that Article 2 does in fact apply. So the question is, that was the predominating factor. So they said, well, the implied warranty of merchantability should then apply. But the defendant asserted that it was immune from that warranty. And here's why. There's a specific statute in Iowa, Chapter 613. It's Section 18(1)A, the Code of Iowa, and it says the following. A person who is not the assembler, designer, or manufacturer and who wholesales, retails, distributes, or otherwise sells products is, among other things, immune from any suit based on strict liability in tort or breach of implied warranty of merchantability which arises solely from the alleged defect in the original design or manufacture of the product. There's an out clause in the statute for Article 2 implied warranty of merchantability. I don't know how many of you knew that, but I didn't. So it has to do with product liability, and they put that in there some years ago on product liability issues. So those kind of things. But basically, the defendant won because the court found that, in fact, that did basically apply. It was not something that could be read around. Found the statute to be clearly stated. Article 2 didn't apply after all because of another statute. The next case is one of the plethora of cases from the. How many people have been involved with agri-processors case? Raise your hands. About 3/4 of the room. That's what I thought. I keep getting information from that too. So I put this agri-processors case in here. It's kind of long, and I actually included a lot of what the court said because the court did such a nice job of describing what I think is something that a lot of lawyers, even those who work in commercial law areas, really don't get and don't really understand, and that's how the processing and negotiation of checks through banks actually works and what their obligations are. I thought the court did a really fairly nice job. And what this case is really about is it's not so much a UCC case as it is a preference case in bankruptcy. What the assertion was is that these deposits that are going in there into a bank were going through kind of a delayed process of going from one account to another account on kind of a sweep. That was what was the transaction. It was a legitimate purpose for it. There wasn't something they were trying to hide the money, but they were being transferred from one account to another. Well, there's a period of time in which something's deposited, in which it becomes a final payment from that deposit, and that's where they talk about the Article 4 transaction and how that works. There's a two-day period in which it becomes a final, and it was being asserted that 2-day period and that periodic wait to go to the other account, which is in the same bank, was a debt, was creating an antecedent debt. And because they were rejecting it sometimes at times and getting insufficient funds because of it. And the long and short of what the court decided here was that no, that isn't an antecedent debt. There's plenty of case law that says so. And they ultimately said that overdrafts don't rise to debt, and determined that the intraday overdrafts didn't constitute antecedent debt, and there was no preferential transfer. So I don't go through the entire case very much because I think it is a fairly complex case, much more so than I've actually included in the materials. But I refer it to your attention for a fairly good review of how the banking negotiation process works. It may be of interest to you. The next case is another Article 2 case. Homeowner alleged that the defendant put in a PEX plumbing system, failed, and that it caused water damage. And the issue in the case was whether or not this implied warranty required a pre-suit notice of the breach of the warranty claim. Did you know that you had to provide a pre-suit notice? Yes, you do. Section 2-607, as adopted in Missouri, provides that the buyer must, within a reasonable time after he discovers or should have discovered any breach, notify the seller of the breach or be barred from the remedy. Well, the plaintiff asserted that he provided the notice by filing the lawsuit. And apparently there's a split of authority on whether that's the case, but in this particular instance, the court decided that you got to provide a specific notice. Filing the lawsuit is not good enough. So I don't know that I've ever seen that done. Have any of you ever provided that kind of notice here in Iowa? I've never seen a case like this in Iowa, and I don't know whether there is a dichotomy from Missouri, but I've never seen a case like that. I'm curious if anybody else has. Anybody out there? All right. The next case we put in here also because it is also an Article 4 case, The Article 4 cases are, again, a little more difficult for a lot of us to deal with because we don't see the transactions. We don't work with Article 3 and 4 as much as we do some of the other commercial statutes. What happened here, and then just to be very summary about this particular case, there was a multi-consumer class action. This wasn't something that was just a minor problem. These were multiple defendants going after a bank for changing their procedure for post-customer account balances. They were taking care of it every time. They claimed that West Bank breached the implied and express duties of good faith when it changed the sequencing order of bank credit card transactions and how they get applied to the balances that come in against their checking accounts, against their deposit accounts. And West Bank argued that Article 4 applied, and the issue in the case is whether an implied duty of good faith under Article 4 was preserved. The court went on to find that there was an express duty of good faith written into the contract between the debtors and the plaintiffs and defendants. That contract is the account agreement. They said that there was an express violation of good faith, but they said there's no implied violation of good faith. There's no implied warranty. Now, I'll have to stand here and say that I don't see that's a big deal in the outcome of the case because they violated the good faith. They ended up having damages. They ended up having to change and make sure that they sent out notices in a way that apparently was more calculated to give everyone actual notice as opposed to just some sort of a lame effort. So I included the Hanji versus Arvis Bank case as a case from Arkansas to show that this same issue keeps coming up. I don't put it in there to explain it anymore, but the issue of this high to low posting on debit accounts is apparently a continuing issue. So you may want to watch for that and the cases that are out there on this type of issue. You may have clients, bank clients, or you may have bank customers who are experiencing problems with this, and these will be good resources to look at, and I refer them to you. The next one is also an Article 2 case, Bedilla versus Walmart. A buyer of work boots sued the seller, Walmart, for breach of warranty under New Mexico's version of the Article 2. Sought damages for personal injury, alleging that the loose soles caused him to fall and suffer injuries while working on it as a tree trimmer. Can't you just imagine this? Guy's up in a tree, boots don't work, he's hanging by his suspenders. Maybe it's just a cartoon in me. An issue was the proper statute of limitations for tort claim under the UCC as a breach of implied warranty and fitness of particular purpose. The tort statute of limitations in New Mexico was 3 years, and the UC statute of limitations is 4 years. Well, that was really one of the problems. The court described that there's a split in other jurisdictions as to when an action is governed by the limitation period in the UCC. The majority view is that the UCC limitation periods applies to all actions for breach of warranties regardless of whether the plaintiff seeks personal injury damages or economic or contractual damages. And it essentially looks at the nature of the right asserted. If the right is based on contract, it's subject to the UCC. And that's what happened here. The product was a subject of a purchase at Walmart. UCC applied. And so that was, they went through an analysis of why they thought the 4-year statute applied and the UCC applied, but you'll see that there is apparently a distinction or a split in authority as to which actually should be applied. So this gives you some notice that maybe if you have that kind of a situation, look to the law of your state, look to the law of this state. I don't know what Iowa would say there. I don't know that I've seen a case on it. JAG Orthopedics. The plaintiffs made claims against the defendants. It arose out of allegations that the defendant's plaintiff's officer manager misappropriated, embezzled hundreds of thousands of dollars from the plaintiff, writing checks to herself, obtaining a debit card, forging the signature of plaintiff's owner and president. So a company had a bad employee, went and did a bunch of stuff at the bank, and the employer plaintiff lost money. And the plaintiff alleged that the bank improperly paid the checks forged by the office manager in violation of its obligations not to, it gives you strict liability when you pay something that's not properly payable. That's an basic Article 3 concept. And the bank moved for dismissal, and under 406, the bank is excused from strict liability for paying on forged document where the customer's own negligence contributes to allowing the alteration of the check and the bank pays the check in good faith. That section provides that the bank will not be held liable for paying on forged or unauthorized signatures where the bank has sent statements of account to the customer and the customer fails to timely notify the bank. Well, those are affirmative defenses. They're two different sections. It's 3-406 and 4-406, and the defendant's got to show that the plaintiff was negligent and that the negligence led to the incorrect payment by the bank. And with respect to 3-406 having to do with those bank statements, it's another defense. You've got to affirmatively state it and assert it. The bank can establish defense under that section if it fails to show that it acted in good faith in accordance with reasonable commercial standards, and you got to show some evidence of that. This is a case where my main comment is when you have these commercial litigation cases, these affirmative defenses have to have evidence presented. You got to get somebody on the stand, maybe an expert, to show that these actions taken by the lender, if you're on the lender side, and I frequently am, you got to show that actions taken by the lender are those that a normal and reasonable lender would take. Many times you can get your own banker up there to show, but a lot of times it will take someone who is either an expert or familiar and can show opinion testimony that the types of things that were being done in this case, that you have to show they were being done, are actually commercially reasonable and ordinary for purposes of the industry. They didn't even do that. The other thing that they should have shown and could have shown is that they actually sent the bank statements to the borrower, to the account holder. I've had a case where that's in fact what we had happen is that I've had several cases like this where someone goes and forges or alters checks, runs it through another bank. They're on our account, and then the depositor goes and says, "Hey, you improperly paid on those checks. I want my money back." And we say, "Well, wait a minute. This is a year ago you did this. We gave you your statements 90 days. You got 90 days to look at your statements and tell us if there's anything improper. You didn't do that." Now, in the case I had, they actually have a case against the other bank where they deposited because they actually looked at the checks. They were actually hand deposited in the other bank before they were electronically passed through to my client. And by the way, if your client is accepting electronically transferred or negotiated deposits, there is no obligation to look and observe the actual signatures on an altered check in that case. But the bank who first took still has that obligation, and they're going to be on the hook for accepting forged endorsements or altered checks. In this case, it was $75,000 or $100,000 worth of altered checks that took place over about an 18-month period. But the last one had occurred more than 90 days ago. Well, my client was able to show, and what this bank did not show, and for some reason didn't put it into evidence, that they'd actually sent out the bank statements to the account holder. This is an evidentiary presentation. I'm just pointing it out that that's why they lost. They didn't lose because the law was against them. They lost because they didn't present the evidence. The next case I wanted to present on is C&H Capital America versus Hunt Tractor. It's a Kentucky case. Now, this is a situation where Hunt Tractor had a wholesale security agreement with C&H's corporate predecessor. Let's call them C&H for now. They financed Hunt Tractor in buying case inventory and equipment, and Hunt Tractor granted a security interest in inventory and equipment, all proceeds of inventory, accounts, things like that. That's pretty normal in a financing transaction. Well, then the son in the corporate ownership borrowed $400,000 from his father-in-law so he could buy Hunt Tractor, the family business. Then later, Hunt Tractor entered into a $500,000 line of credit with another bank, Commonwealth Bank. And with the bank loans, Hunt Tractor maintained a checking account with Commonwealth. The Commonwealth did a sweep on that periodically on that account, deducted from the checking account on a daily basis to pay down on the bank loan balances. Now, Commonwealth Bank held a security interest in the funds deposited in Hunt Tractor's checking account. Now, normally, the bank that had, if you have two security agreements, and one says we have a security interest in accounts and bank accounts, deposit accounts. You have to say deposit accounts, not just accounts. But a bank in whose trust you are actually depositing those accounts also has a security interest in them. They are the higher perfecting and priority bank or secured party because they have the deposits in their possession. As a result, they have first priority even if you had a filing that took place earlier with a previous secured party. So this bank is making these sweeps. They have the right to do so as a secured creditor. However, when do you have a right to take over your collateral? What's the key? Default. All right, here's what happens. Hunter Tractor struggled to make payments and to pay CNA, and they received a check from the Kentucky Department of Transportation on payment for a whole bunch of backhoes that they were selling. It's a good thing, a great big receivable. They deposited in the bank. The bank swept $348,000 of it, and then they took and applied the rest of it to the line of credit that the bank had, paying them off. Did they have a right to do that? They set it off. Now that's the real problem, is that the court found that Article 9601 says that secured parties' rights upon default, and that's when they arise, and after default, a secured party has the rights provided in part, which includes the right to take possession and the right to proceed to enforce against deposit accounts. But the bank held that CNH had a perfected purchase money security in its collateral and the proceeds, and Commonwealth only had its superior rights to the deposit account if Hunt Tractor had defaulted. And in this case, the bank couldn't show that there was any default. So they got to give that money back to the secured creditor who had the account receivable and the deposit account instead, because they did have a default on their payment. Again, it's just a situation where I don't know whether there wasn't any default or whether they simply failed to prove there was, but it looked like there wasn't any default. They tried to take the money fast. The next case is one that it seems to me pretty self-evident, but I thought it was an interesting case for you to look at. It's also an Article 2 case. Plaintiff, I mean, you can see by these facts. I laid out the facts because I thought they were kind of fun to look at, and maybe you find them interesting too. Plaintiff bought a used motor vehicle from the defendant for $1,895. We are not talking about a Maserati here. The bill of sale indicated the vehicle would be sold, quote, as is, as seen. The sale also included a form from the New Hampshire Division of Motor Vehicles, DMV, titled, in big bold letters, Notice of Sale of Unsafe Motor Vehicle. Guys, this is getting better all the time. Which stated in pertinent part, quote, if you are considering the purchase of a used vehicle which may not pass New Hampshire safety inspection, you have the right under RSA 358-F to request that the dealer inspect the vehicle prior to sale and list the defects which must be corrected before the inspector sticker will be issued. Unquote. The DMV form contained the following notice. The motor vehicle described herein will not pass a New Hampshire inspection and is unsafe for operation. End quote. How much notice do you really need, folks? I mean, this reminds me of the cases where we have product liability cases that says you have a duty to warn somebody not to store gasoline next to a water heater. Just hate those cases. Why would you not know that? But apparently that's important. But here, I wondered, as I was reading this, I says, Oh, please don't let the creditor lose here, please. Anyway, by signing the form, the plaintiff acknowledged that the vehicle wouldn't pass. The plaintiff actually signed this form. Well, you can guess what happened. The plaintiff drove the vehicle home, discovered that it wouldn't pass inspection because the frame was completely rotted almost to the point where it was dangerous. They alleged that the vehicle had 2 big rust holes, one the size of a softball, and because the holes completely compromised the structural integrity of the vehicle and failed inspection, was unsafe. Plaintiff brought a small claims action. Yes, this started in small claims. The trial court ruled in favor of the defendant. Did they stay in small claims? No. They filed an appeal on this case. The plaintiff argued that the trial court erred by failing to rule that the defendant breached the implied warranty of merchantability. There we go again. Contending that to the extent that the trial court found that he'd waived this implied warranty, the court was wrong. The implied warranty of merchantability is set forth in 2314 of the UCC, and I set it out there so you can see what it says. It's got a lot of things that you would think, yes, a used car ought to include them, these warranties. But the court referred to the official comments which state that the question whether the warranty is imposed turns basically on the meaning of the terms of the agreement as recognized in the trade. Goods delivered under agreement made by a merchant in a given line of trade must be of a quality comparable to that generally accepted in that line of trade. With regard to used goods, the court found that the official comments state that such goods, quote, involves only such obligation as is appropriate to such goods, for that is their contract description. In other words, if you're buying used goods, this implied warranty may not be good at all. It might not be good because, and in particular, when you have a contract that tells you the very quality that you're buying. There's no warranty on anything to begin with. So, I was happy to find out that the defendant was actually exonerated again with the notice. I put this next case in here not to describe it in detail, but just let you see how complicated the battle of the forms can get sometimes under Article 2. What we have here is we have a correspondence between parties in a purchase of goods. It's your normal, here's my first purchase order. No, we've got some other things to talk about. Well, here's I emailed my second purchase order. But the first purchase order has a whole bunch of terms on it that are not part of the second purchase order, but they are certainly not withdrawn by the second purchase order. And what we had was we had back and forth emails going on between these two parties. Not only were the forms that they sent, but the emails themselves became part of the total transaction. So when you have clients or when you're dealing with somebody, and if you have to be selling something yourself, be aware that the court's going to take into consideration the entire circumstances of this trade-off. Now, generally speaking, when you make a counteroffer, it revokes the previous offer. That's not really what happened here. No one really revoked it. They just kind of added and mooshed about some more terms and discussion about price. And what became the real issue is that the original purchase order had a venue provision. Second one didn't. First one had these extra terms and a kind of I'll call it the boilerplate sheet, and it had a choice of venue provision. Well, as luck would turn out, the purchaser didn't like what happened and started suing, and the seller said, hey, wait a minute, you're suing me in the wrong court. The venue provision provides. They say, what venue provision? We don't see that in the one we signed. The court found that the venue provision from the original discussion was still applicable, to make a very long story short. And they took into consideration, and I describe out in some of the court's very well stated discussion of the law as to how you go about analyzing in an Article 2 situation, purchase of goods, what's the deal? What's the contract? It could be very broad based on the negotiations of the parties unless they're careful. What they ultimately found was that, as a matter of fact, the defendant's correspondence, together with the conduct of the parties, indicate that the parties had reached an agreement and that the defendant had accepted the offer. The emails, the additional forms, and the second PO did not negate the initial PO, but memorialized it, the prior acceptance, and finalized the details of the offer. Well, I said the moral of the story is to be careful what you're accepting, because the UCC may consider terms not in the original form or that you might think were just new terms and discussions. The following case is BMAC Trucking, and this is a case which, frankly, you might find is a little bit more of a normal result in this battle of the forms. And what it ultimately found was that when you have two different purchase orders going back and forth, when you make a counteroffer, it rejects the first one. That's what happened in BMAC. So I guess I wanted to make sure that you see the dichotomy between two cases, one where there's a great deal of conversation, and another when there's really very succinct back and forth negotiation of saying, no, I don't like that, we reject that. And they produce another one, and the offer, making a new offer, basically is a rejection of the previous offer. That doesn't happen, they didn't, but you can imagine in this day and age where you have a lot of conversation going back and forth by email. How many times have you asked your clients, quit putting things on email, you're just making yourself a paper trail? Well, there it was. In the first case, we had this paper trail of conversation that actually became part of the entire environment of the negotiations and ultimately part of the terms. Whereas in the second, it was a much more succinct conversation of back and forth. I don't like that. Here's my counteroffer. The second one became the actual offer. The first one was rejected. Therefore, we had very succinct and understood terms. So those are the cases I've selected for your entertainment today. Do we have any other questions regarding UCC update? Yes, sir.
Back to your JAG orthopedics and the bank's reasonableness in a check, turn it into a hypothetical, but if somebody sends me a bank draft on a nationally recognized bank, I take it to my bank and then I tell them to forward a lesser amount in the form of their bank draft to Whitfield and Eddy to Gary Norton. You negotiate the bank draft that I purchased, and then my bank calls me up and says, you know, somebody forged that bank draft that you deposited. Who do you think's on the hook for that?
Usually the person who at first accepted that is going to get on the hook for the most part. The bank who, the home bank, I'll call them, the payor bank, as they say, is the one where the account is. They're responsible for making only payments that are properly payable. If you've got a forged endorsement or an altered check, that's not properly payable. And as a result, they have an obligation, a strict liability to make good on the check, and the customer gets reimbursed. But there are these defenses that you have to assert, and they are those defenses. Now, if it's one that just happened last week, and the customer says, hey, that was improperly paid check, the bank's on the hook. The bank with the account's on the hook. Now, they may actually have rights to go upstream to whoever negotiated it to them, because there are warranties from those who bring it to you. So they might be able to go and say to the bank that actually sent it on downstream to them for deposit, you've also breached your warranty on the negotiable instrument, and you get to go against them.
Where there appears to be no upstream because it's a scam.
Yeah, you get to a point.
So somebody's got a good laser printer that's sending out Bank of America.
That's right. You get to a point where you get to the bad guy, and the bad guys, you either can't find him or he doesn't able to pay, and then that happens quite a bit. I've had cases. I mean, I've had a lot of cases like that over the years. I had a case in Texas one time where no less than 11 banks were involved around the country on the negotiation. I sued them all. Unfortunately, it was also during the time when things were going rather badly for banks, and the principal bank that against who I thought I had a sure collection was M Bank Dallas. I don't know if you remember M Bank Dallas, but they went FDIC on us the day I sent out the discovery. So I didn't get to collect from them. But the good news was that the depository bank in that particular case had insurance, and they were able to pay. It was a nice payday for the client. But yeah, you basically ended up suing the entire backfield and throw everybody out till you find the ball. Any other questions, folks? Well, thank you for the opportunity to present here today. I really do enjoy talking about these kind of things. I did not channel Steve Turner, and so he and I are friends, but that's where it stops. And I think that I hope that you learned a few things. And if you have a chance to read these cases, I think that there'll be good resources for you in the coming months. Thank you very much.